Hi, everybody. It's David Goldstein and Doug Rowe from the Certilman Balin law firm, and we're going to be doing the 2022 nonprofit legal update. We're going to cover some important employment law matters and some governance matters. And Doug Rowe, who is the head of our labor and employment practice group, is going to start first. So, Doug, turning it over to you.
Sure. Thank you. Thank you, David. So I'm going to start with a topic that's near and dear to me because so many of our clients have issues with understanding the wage and hour laws and complying with them, and then dealing with Department of Labor audits when they're not complying, and or federal or state lawsuits, and sometimes, oftentimes, class action lawsuits because of the lack of compliance. So generally speaking, employers are required to comply with the wage and hour laws. Generally speaking, they have to pay overtime where employees work more than 40 hours in a week. They have to pay minimum wage. There are some laws in New York that are truly unique to New York. For example, there's a law called spread of hours pay, which requires employers to pay employees, and these are generally minimum wage employees, an extra hour of the minimum wage at the minimum wage payment for every day the hours of their employees exceed 10. And what that means is that if an employee works 5 hours in the morning, takes a 3-hour break, and works 5 hours in the evening, even though the employee only worked 8 hours because their hours exceeded 10 for that day, technically they would be entitled to an extra hour at the minimum wage for spread of hours pay. And that's a law that sometimes employees are not aware of. That's actually how it usually comes up, that it comes up in an audit or a lawsuit, and that's when the employer first becomes aware of this law. There's also a law in New York that requires employers to give their employees a wage notice form. It's a form, it's on the Department of Labor website. Employers can access the form. The form is in virtually every language that the employer could have their employees speak. The form has to be provided to the employee in their native language, but it has to be completed. On the left side is the employer information, in the middle is the pay rate and pay date, on the right side is the signature line for the employee, and it has to be signed by the employee and it has to be retained in the employee's file for 6 years. The reason why I stress the layout of the form is that we've been involved in litigation where the employer actually, for example, made a typographical error in their address or didn't fully complete the form, and the exposure for not having the proper wage notice form is $5,000 per employee. So we actually had an issue in a class action where there were 600 employees, and every one of the wage notice forms was arguably incorrect because it had the wrong employer address on it. And the plaintiff's attorney in the case took the position that my client owed $3 million because of this typographical error. So it's just something to be aware of. And when I bring up examples like that, you'll see it's really about compliance with the labor and employment laws, but it's actually about strict compliance. It's not just, do you give your employees wage notices, but are they completed? And make sure of that. One of the other issues in the wage and hour laws is overtime. But what happens is a lot of employers believe that merely because they pay an employee on a salary basis that the employee is not entitled to overtime. That's not the law. The law is that the employee would not be entitled to overtime if the employee is exempt from overtime. There are certain exemptions. There are typically white collar exemptions, such as an executive exemption. In order for the employee to fall within the executive exemption, the employee has to supervise at least 2 full-time employees, has to have the right to hire and fire or effectively recommend same. But also, and that's the federal law, but also under state law, the employee has to reach a certain salary threshold. So if the employee otherwise satisfies the duties test, but is not paid at least, and this is for Nassau, Suffolk, Westchester, and New York City, at least $11.25 per week, which is $58,500 per year, then the employee is not exempt. So that's, again, something to be aware of when you're considering whether an employee is exempt or not. You also, so it's essentially a duties test and a salary test. There are other exemptions, generally speaking, to be aware of. Those include the administrative exemptions, such as an HR director, or perhaps a controller, maybe or maybe not. It's not automatic that merely because an employee has a title, they're exempt. So it's really, there has to be an analysis of the duties to determine whether an employee satisfies the exemption. One of the issues that we come across in the nonprofit world is independent contractors, and whether a particular person is an independent contractor or an employee. I mean, generally speaking, and this is just my rule of thumb, if they look like an employee and smell like an employee, consider that they're an employee. You can have a person sign an agreement that says, I am an independent contractor. That's not going to carry the day. It's really, is that person supervised? Does the person use independent discretion? Does that person actually have a business that they operate? And does that person, is that person paid like an employee, or does that person bill the nonprofit on a weekly or monthly basis? You know, these are some of the factors that the courts and agencies look at. Also, does that person regularly perform their duties from the employer's office and use the employer's supplies and equipment? If so, again, they're going to look like and smell like an employee, and they're probably going to be deemed an employee, even though they've been classified as an independent contractor. Also, you know, specifically related to you know, nonprofits is the issue of volunteers. You know, it's pretty well settled, you know, that volunteers are not employees and don't have to be paid. But we've had cases before the Department of Labor where somebody who started out as a volunteer was actually converted into being an employee because of the nature of the relationship. The nature of the relationship changed to the point that the volunteer started being regularly assigned to be a driver. The volunteer was given a schedule. The volunteer was accepting you know, some level of supervision. The volunteer was being reimbursed for certain expenses and using a company bus to perform the services. That volunteer filed a claim with the New York State Department of Labor, and the nonprofit had to pay. It was close to a 6-figure settlement because of the way the volunteer was treated. So, you know, generally speaking, when you think about a volunteer, unpaid volunteers may not replace or augment paid staff to do the work of paid staff, do anything but tasks traditionally reserved for volunteers, be required to work certain hours, be required to perform duties involuntarily, be under any contract of hire by any other person or business, or express or implied, be paid for their services except for expense reimbursement. And yes, volunteers can receive a stipend, and typically it's just for reimbursement of expenses. So it's just, it's something to bear in mind. And again, this goes to really the issue of classification and misclassification in the same arena as exempt versus non-exempt from overtime, in the same arena as independent contractors versus employees, and the same arena as, you know, volunteers versus employees. And again, you know, I stress the importance of proper classification because, you know, the potential damages for misclassification are so significant. You know, they can be, you know, IRS, you know, interest and penalties. It could be liquidated damages for unpaid overtime. It could be, needless to say, attorney's fees, both for the nonprofit and for the plaintiff's attorneys. So, you know, again, compliance with the wage and hour laws, I can't stress that enough. So with that said, this is another year, and it's a new year for new employment laws in New York. I'm going to touch upon them. These new laws really affect, you know, private sector employers and nonprofits as well. There was a minimum wage increase that went into effect at the beginning of this year. I mentioned the salary threshold increase. This year, last year, a recreational marijuana was legalized. So, you know, I would stress there that, you know, the law generally is that employees are protected from disciplinary action or discrimination for their lawful use of cannabis during legal recreational activities and use before or after hours. You know, needless to say, if an employee comes to work impaired, that's, you know, that's not protected. You know, I would stress there, though, that employers should be aware of this new law. And, you know, I've seen it a few times. They should change their, you should be advised to change your employee handbook to ensure that you're in compliance with the employee handbook. One of the most important new laws that affect nonprofits, you know, again, all private sector employers as well, is the expansion of New York State's whistleblower law. This went into effect on January 26, 2022. I'll try to simplify this. Under the old law, an employee was protected against retaliation after reporting or threatening to report an activity or practice that was an actual violation of the law and posed a substantial danger to the public health and safety. So it was very limited. It was really about healthcare fraud and abuse. It was limited to that. The law has now changed. Now, if an employee complains, there doesn't have to be an actual violation of the law. All the employee has to have is a reasonable belief that there was a violation of the law. So if the employee complains, you can't retaliate against that employee if they have a reasonable belief that there was a violation of the law. But also, it's not limited to health and safety. It's now unlimited. If an employee complains about a violation of has a reasonable belief that there's a violation of any law, that's protected. So this is a very significant change to New York law, and will definitely have an impact on nonprofits. Again, it widely broadens the scope, and also just bear in mind, and this really goes to the issue of notice. You also have to give notice of rights to employees of this new law, and you can do that through a notice that's posted in the workplace, and also I would recommend that it be done also through the employee handbook. There was some expansion to the New York paid PFL, paid family leave. It clarified intermittent leave as well. Again, last year, the regulations had already indicated that employees would be entitled to 67% of their salary during a valid PFL leave. Discrimination and harassment issues for New York employees, that is also always a hot issue. I think it was several years ago that the New York State implemented an expansion of the discrimination laws on the basis of hair. So that has to be taken into account. Sexual harassment policy is still a requirement in New York State, and also the annual training requirements, which went into effect several years ago, remains in effect. I know a lot of employers, when the law first rolled out, would do the sexual harassment training almost immediately. Since then, the training, a lot of employers have just not dealt with it. The fact is that New York State has not audited companies. We haven't seen that yet, and they haven't indicated that they would impose fines for employers who didn't have the annual training. But nevertheless, we continue to recommend that the annual training be done, as it is a legal requirement. Several years ago also, there was a new law that was passed that requires lactation accommodations in the workplace. I just wanted to mention that again, because a lot of employers are not necessarily aware of that. And we've had several lactation discrimination cases, believe it or not. A new law went into effect just in May. It requires employers to give notice to their employees that if they monitor their employees' internet usage, telephone conversations, email transmissions, etc. So if the employer engages in electronic monitoring of employees, they have to post a notice in a conspicuous place that's readily available for viewing in the workplace. They also must furnish new employees with written notice when they're hired, and the employees should sign off on receipt of that policy, and they can do so either in writing or electronically, and it can be contained in the employee handbook. Another reason why employee handbooks should be updated. Workplace health and safety protections is of paramount importance, as we've all seen over the past several years. Several new laws were passed, both federal and state. The federal law, some of the federal laws went by the wayside, but the state laws remain in effect. Late last year, New York State passed the HERO Act, which requires every employer to have a airborne infectious disease policy. That policy has to, at this point, remains in effect, and also employees have the right to form a safety committee if they choose to do so. So that law remains in effect. And then the COVID-19 legislation remains in effect. We have these issues almost on a weekly basis, but New York is unique because they have a sick leave law that requires employers to provide larger employers to provide at least 5 sick days for all their employees. But there's also a COVID-19 sick leave law, which entitles employees to take sick leave for COVID-related illnesses, and that sick leave doesn't apply to the New York State sick leave. So again, that's something to be aware of. There are 2 separate sick leave laws, the New York State sick leave law and the COVID-19 sick leave law. There's also a vaccination leave law entitling employees to up to 4 hours of leave to become vaccinated. Needless to say, while COVID-19 seems to be waning, these laws remain in effect, and you know, it's a regular issue in the workplace. I have a couple of more minutes and maybe another slide. So there are also some New York City specific employment laws. There was a law that was scheduled to go into effect earlier this year, but it was put off until November 1st. But effective November 1st, New York City is requiring that all job posts have a salary disclosure, which will include minimum and maximum salary ranges offered for the position. There are penalties, and that's, you know, if you post a job on LinkedIn, you have to comply with that law. If you post a job on Indeed or Craigslist, you have to, or just on the internet, you have to comply with that law. So it's just something to be aware of. New York City Fair Chance Act, just as a reminder, you know, if you're doing criminal background checks on employees, the process needs to be that you make the job offer, contingent on a satisfactory background check, criminal background check, and that once the criminal background check comes in, you know, then you have to, if there's a criminal conviction history, then you have to evaluate the convictions against the position that's being applied for, and evaluate the age of the person when the crime was committed, how many years has it been since the crime was committed, and whether the crime in any way relates to the position that's being applied for, before you can decide whether to continue to hire that person or not. And one other law that's going into effect in early January 2023, also unique to New York, is artificial intelligence in recruitment, which is a hot topic before the EEOC, especially. Actually, New York City passed the first law, but if you're going to be using that in your recruitment efforts, artificial intelligence, then you have to make sure that the process is compliant and not discriminatory, and you actually have to have an audit of your processes. I'm just going to touch upon one other issue, which, you know, how it relates to the workplace is yet to be seen. But, you know, with the fact that Roe v. Wade was just overturned, I know it's now become an issue for employers as well in the workplace. And, you know, what we've seen so far is that some companies are actually dealing with it by including increasing travel benefits to cover healthcare procedures, you know, in the event that an employee needs to have an abortion. And, you know, if that is going to be evaluated, and any other procedures, if any other procedures are going to be evaluated in the workplace, you have to make sure you evaluate the legal risks and see whether there's a conflict in the state laws. That's the end of my slides. I tried to give an overview of, you know, hot topics in New York employment law, but, you know, the takeaway really should be, you know, compliance is key, you know, and as always, you know, this is more of a HR issue than a legal issue, but, you know, it's just a reminder that in this day and age where it's difficult to retain employees, just continue to consider, treating employees with dignity and respect and fairness and accountability and consideration to their needs. And those are my takeaways. Doug Rowe, thank you for listening. And David, I'm going to turn it over to you at this point. Thank you.
Thanks, Doug. And there were a couple of questions, and maybe we'll have time at the end to circle back to them. Doug, those questions are in the chat, so
Okay.
maybe you can take a look at them. But if we don't, and we may not, because we just have a short amount of time, please feel free to reach out to Doug or to me. You've got our contact information. So I'm gonna focus on the not-for-profit corporation law, and maybe a good place to start is really there's one significant change that you should be aware of in the not-for-profit corporation law in the last year or so. And I'm not going to spend a lot of time on it, but if it applies to you, please feel free to call me or email me, and we can talk about it in more detail. And that changes that there was a pandemic exception that was set to expire on December 31st, 2021, that allowed only during the pandemic virtual membership meetings, as opposed to virtual board meetings, which were always allowed. Virtual membership meetings were not allowed except in the pandemic, and that exception was made permanent by a change in the not-for-profit corporation law. So now, if you're a membership nonprofit, your membership meetings can be done virtually. There are, as you might expect, some rules about that. So if that applies to you, there are rules and best practices. Please reach out to me, and we'll talk about it. Okay. So we're going to focus on nonprofit governance for the rest of our time, and I'm going to just really quickly, and I apologize for talking fast, but we've got a lot to cover in a short amount of time. We'll talk about some governance fundamentals and basics, the fiduciary duties that apply to board members, and then some traps that nonprofits often fall into. And hopefully we'll have some time. I want to touch, if we can, on some of the governance aspects of the IRS Form 990. So fundamental concepts: directors of nonprofits have legal duties known as fiduciary duties, and there can be personal liability to directors for breaching these legal duties. And both of these two concepts should not come as a surprise to directors and officers, and it's really critical that your board be aware of both the duties and the potential liability for failure to fulfill them. The three fundamental legal duties of a nonprofit director under New York law: the duty of care, the duty of loyalty, and the duty of obedience. Duty of care is in the not-for-profit corporation law in 717A. It's basically the oversight function. And 717A provides the director has to discharge the duties of his or her position in good faith and with the care an ordinarily prudent person in a like position would exercise under similar circumstances. And obviously, to do that, it will require familiarity with the organization's finances and activities and regular participation in its governance. And a very nice statement of how that can be used in litigation against board members is found in the summons for the Healing Arts Initiative lawsuit from 2016. That is in your materials. And right at the top, when you look at it, it lists a bunch of individuals as defendants, and those individuals are the members of the board of directors of Healing Arts Initiative. And basically, they were sued for violation of 717 that we just talked about and 720 of the not-for-profit corporation law. They neglected, the allegations were that they neglected, failed to perform, and or violated their duties, including their duty to act in good faith with the care an ordinarily prudent person in a like position would exercise under similar circumstances in their management and oversight of HAI by permitting $750,000 to be stolen by former employees, by hiring non-independent auditors, negligently hiring employees, and otherwise breaching their duties. And that highlighted language in bold is right from the statute from 717A. And these actions by the board constituted breach of contract, breach of fiduciary duty, violations of the not-for-profit corporation law. And the suit was for an amount not less than $750,000 caused by defendant's conduct, plus attorney's fees and punitive damages and removal of the board of directors. So this is a very straightforward statement of oversight duties, breach of those duties, and potential liability of board members as a result. So a quick roadmap of the duty of care, and much of this is in the supplementary materials that were provided to you. I urge, and if you've heard me speak before, or if you've met me, you know that I always urge my clients and everyone in the nonprofit sector to read the Attorney General's guidance document entitled "Right from the Start: Responsibilities of Directors of Not-for-Profit Corporations." And that really is it's written for non-lawyers, and it has a very clear explanation of the fiduciary duties of board members and how board members should go about fulfilling those duties. And I ask my clients to read that document. It's about 8 or 9 pages long. I ask them to read it at least once a year. You've also got in your materials the Adelphi litigation, which goes into detail about how the board in that instance failed to fulfill their fiduciary duties to Adelphi. You've also got the complaint in the Dowling College litigation, where 13 individuals were sued as board members of Dowling, and also the CFO was sued for breach of fiduciary duty. You've also got an Attorney General guidance document on internal controls and financial accountability for nonprofit boards. Policies and procedures developed by an experienced accountant and experience in nonprofit matters are an essential part of those internal controls for nonprofits. And that's something that the board should be focusing on. And then you've got a guidance document from the Attorney General in your materials on audit oversight, and that's a critical part of the nonprofit governance regimen in New York State. The only committee that has its own section of the not-for-profit corporation law dedicated to it is the audit committee, and that's section 712A. Next duty after the duty of care is the duty of loyalty. That it is what it sounds like. The director must act in the interest of the organization, requires undivided allegiance to the organization's mission when using the power of a director's position or information concerning the organization or its property. And where we see the duty of loyalty most play out in nonprofit governance is in the area of conflicts of interest and related party transactions. And those provisions in the not-for-profit corporation law are very important provisions that were added in 2014, effective July 1st, 2014. And they are very much in the spotlight in terms of litigation and disputes involving nonprofits, and also in Attorney General enforcement actions. The third fiduciary duty is the duty of obedience. It's the least understood and most often neglected of the 3 primary legal duties. The reason for that seems to be that the other 2, the duty of care and the duty of loyalty, exist in the for-profit world, but the duty of obedience is strictly a not-for-profit law concept. Duty of obedience is what it sounds like: to ensure that the organization complies with applicable laws and regulations and its internal governance documents and policies. So it's kind of a two-headed monster. Compliance with applicable laws is even more difficult than it sounds like, because of course there are multiple layers of laws and regulations. There are state laws, local laws, federal laws. The compliance of laws and regulations includes compliance with the not-for-profit corporation law. And I want to take a second to focus on that. The standard for compliance with the not-for-profit corporation law is not a best efforts under difficult circumstances. The not-for-profit corporation law is a law. It has many mandatory requirements and procedures that can't be varied by what your bylaws might say. So that's very important to be aware of. There are very often bright lines that are rigid and inflexible and unforgiving. example I like to use, not a pleasant one, but at the height of cemeteries in New York, if they're not owned by religious groups, are required to be nonprofits and are subject to the not-for-profit corporation law like other nonprofits. And one of my cemetery clients at the height of the pandemic sought to get a waiver to allow them to delay their annual membership meeting, and they couldn't get it. And so there you go. Inflexible, unforgiving, and so best be aware of what the bright lines in the law are. The other prong, the second head of the two-headed monster, compliance with internal governance documents. The core documents, and there are others, of course, including policies like the conflict of interest policy and investment policy, but the two fundamental documents are the certificate of incorporation and the bylaws. Here's a trap that nonprofits often fall into. Your corporate purposes are set forth in your certificate of incorporation, and the legal concept is that a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty. And one of the central oversight functions of directors and officers is to make sure that the use of assets by the organization is consistent with the purposes set forth in the certificate of incorporation. So I got a phone call also during the pandemic from an accountant who had a nonprofit client that started a wonderful new program, very much needed in the community, to address food insecurity. But there was a fundamental problem. The activity, though vitally important, fell outside of the purposes set forth in the certificate of incorporation. And remember, a diversion from corporate purposes, no matter how worthy, is a breach of fiduciary duty, and the result can be potential personal liability of board members for failure to strictly adhere to corporate purposes. I had another instance during the pandemic where I had a phone call asking about a board chair's decision to conduct an email vote on nominations for open for board seats at the upcoming annual meeting. The chair stated in an email to the board that under normal circumstances, the board would have a meeting to vote on nominations, but because of the pandemic, the board would vote by email instead. Sounds reasonable, but it's going to slam up against some mandatory provisions in the statute. And this is a trap that nonprofits continually fall into. It's a little bit counterintuitive. Email voting by the board is something that you can never do. There are only two ways that the board can act. One is at a meeting, which can be in person, by conference call, or by video conference. The other way, the only other way that the board can act, other than at a meeting, is by unanimous consent in lieu of a meeting. And that unanimous consent can be by email or written, but the key there is it's unanimous, and that is not voting, right? So if you have 50 board members, 49 of them give you an email consent, and the 50th abstains or is unavailable or out of touch, that is not a valid board action. And the effect of missteps in this area is that board decisions can be found retroactively to be invalid and improperly authorized. Minutes are a critical area. I'm going to fly past this, but minutes are essential to document that you've done things right. And if your minutes don't do that, they should really be a checklist to demonstrate that the board fulfilled its fiduciary duties and complied with all the required procedures in each instance. And if you don't have minutes to document that, even if you did things right, 3 years down the road, you're going to have a problem demonstrating that you did. My mantra is always nonprofit governance. It's not rocket science, and it isn't. It's really commitment and attention to detail. Process, lots of procedures, mandatory requirements. My view is that no nonprofit, no matter how large the board, no matter how many lawyers and accountants on the board, no nonprofit can do this governance heavy lifting without board education. And it requires attention to detail, awareness under even extraordinary circumstances, and discipline and commitment to compliance. So I'm going to skip to the IRS Form 990, because I just see this being an issue for nonprofits and for boards all the time. The 990 is ubiquitous. It's available on lots of different public websites, including through the Attorney General, the IRS, GuideStar, and others. What I want to draw people's attention to is that the 990 is signed under penalties of perjury. It says, "I declare that I have examined this return, including accompanying schedules and statements, and to the best of my knowledge and belief, it is true, correct, and complete." And that's language that that regulators in enforcement actions won't hesitate to use against nonprofits. The governance section of the 990 is Part 6. Section A talks about the governing body and management. There are questions about independence, relationships of board members, officers, and key employees, if they've got family or business relationships. These are basic questions, but you would be shocked to realize how often they're answered incorrectly. Sometimes an accountant fills them out with aspirational answers or answers they think are right, and is expecting that the board is reviewing it and reading it. And so sometimes you see answers that are very much divorced from reality on the 990 that actually gets filed. There are questions about members in this part of the 990. Do you have members? Do members have the power to elect the governing body? Any governance decisions reserved to members? If you have members and you say yes, it's probably mistaken to say no to the follow-up questions, because under New York law, members do have the power to elect the governing body, and there are certain governance decisions that by law are reserved to members. The 990 asks you about minutes. Do you keep contemporaneous minutes of board and committee meetings? It also asks, did the organization become aware of a significant diversion of the organization's assets? I'm going to try to fly through Section B, which talks about policies. Interestingly, if you look at the language in the form, it says Section B requests information about policies not required by the Internal Revenue Code. So this section is a governance body scan to see what your practices are, even though the IRS can't require you to have any of these policies. And there's sort of an embarrassment factor here. One of the questions is, has the organization provided a copy of the 990 to the board members before filing the form? And then you have to describe that process. That's something that gets botched all the time. So I urge people to be attentive to that in terms of what you say in the 990 and how you describe your process. And then there's a question on, do you have a conflict of interest policy? And then it asks you to describe it on Schedule O. So sometimes I see organizations say, yes, we have a conflict of interest policy, and then they describe it in a way that has state law implications. For instance, if I said, yes, I have a conflict of interest policy and it requires annual disclosure by board members and officers of conflicts of interest, you have then said in writing that you're violating New York state law, because New York state law requires not only annual disclosures, but disclosures throughout the year if a conflict arises. So, so attention to detail in governance in general, and in the 990 in particular. This is not rocket science. It just takes the right level of commitment, process, and procedures to make sure you get this right. And I'll end with that reminder. It's not rocket science, but we need to pay attention. And with that, I thank everybody for your attention. I apologize that we didn't get to questions, and I urge you to reach out to Doug and me with any questions that you have. Thanks, everybody, and enjoy the rest of your day.